Now, changing topics, we get to discuss another topic off COVID-19. And I didn't think the day would ever come that we would do this, but we're getting into it. We had this big US Supreme Court case decision, Bostock versus Clayton County, Georgia, on the sex discrimination ruling. And the US Supreme Court held that an employer who fires an individual merely for being gay or transgender violates Title VII of the Civil Rights Act of 1964. There's a lot of different court opinions on whether the Title VII applied to gay or transgender individuals, and so this makes it clear that it does. And so it's a big development on the federal level, but now for California, what does it matter a whole lot? And not really. I mean, California, we've already, these have been protected categories already under California law. So there's not a whole lot of change that we're gonna have to have here in California. But I do recommend for employers that are dealing, and I think it was about half of the states had already recognized gay and transgender individuals as a protected category. The other half of the states didn't recognize it. They were just acting under Title VII. So to the extent you're dealing in other states, you might have to update the handbook in these other states now, or if you're an out-of-state employer coming into California, you should have already been complying with California law, but take a look how those policies interact from other states. That's the one recommendation we have coming out of this. And just as a reminder, California law has already had a lot of regulations on this, and dating back a couple of years now, dealing with bathrooms, that allowing employees to use bathrooms that correspond to the employee's gender identity or gender expression, and also gender neutral signage for these facilities as well. And also, California law requires that employers can impose grooming or dress code standards that are inconsistent with the individual's gender identity or gender expression. And there is no business necessity exception to these requirements as well. So the employer must approach this with caution and talk to their legal counsel to the extent there's any different requirements for gay or transgender individuals, different type of grooming or dress code standards for them. And it's been illegal under California law now for some time to discriminate, retaliate, harass against an individual because of their sexual orientation, or if they've been a transgender individual. And it's also illegal to discriminate against them if the transgender employee is transitioning or in the process of transitioning or is perceived to be transitioning as well. And actually on this slide, I want to go back to this. And I think this could be a tricky issue for a lot of employers. You know, if the employee asked to go by certain pronouns, or use different bathroom facilities, or different names, the employer has to abide by that under California law as well. Now, California law, barring discrimination, applies to all business practices, and this includes hiring, applications, working conditions, and any participation in training or programs of benefits to the employees. Now, California law has already, as I mentioned before, protected sex, gender, sexual orientation, gender identity, gender expression as protected categories, but put a few of the other protected categories here on this slide. And under California law, it is very wide, and a lot of different categories are protected that aren't protected on the federal level, but because they are here protected in California, the employer has to abide by the more stringent requirements here in California.